Great day, great day. Beautiful day outside. Peace to the gods. All right, today I kind of wanted to have a discussion about some things, because I kind of go around on the internet. I kind of listen to other videos and everything, kind of pay attention to, because it's a lot of people who are interested in this subject and have various opinions about of what to say in court. Okay, so today's lecture is going to be about the courts and what to say in court.
Real talk, real people, real radio. HighFrequencyRadioNetwork.com.
Now, first of all, if you're new to this, let me just tell you this. I've been doing this for 13 years. There isn't anything that I haven't heard. I've heard about appointing the judge as the trustee. I've heard about subrogation, asking for the bid bond, acceptance for value, giving the judge the birth certificate in court, dropping it over into the well of the court, saying, I'm not that person, arguments, that's not my name, all of that. Just about everything, my nationality defense and everything. I've used just about every one of them in court except the nationality defense. I've never used nationality in court. But just about it, walking out of court. There's a story about, if you, this guy, he was talking to the judge and he won the case and then he turned around to walk out and then the judge called his name and asked him to take some gum out of his mouth or something like that, and he did it, and then the judge had him arrested because he followed the orders of the judge, so he submitted to the judge's jurisdiction. You're going to hear about all of this stuff if you've been doing it for quite some time. All right, but here's the thing. Because, I'm hearing people say, well, you don't have to file a UCC1 or study all this stuff. You can just go in court and say a few magic words and the case will magically disappear. This is where, in the school of thought that I came from, why we always say, you ask that person, have you been in court before? All right, because here's the thing. It's not to say none of this stuff ain't real or what they may be telling you is not true. All right. The thing is that the experience in court, what it does is it lets you understand how they are prepared for a lot of the things that you come into court with. Okay, because they're looking at YouTube and studying all this stuff too. There's a book called the Anti-Sovereign Government Movement book. You can Google it on the internet if you don't believe me and see all the things in there. They talk about common law courts. They're talking about all this. And I had an attorney tell me that the judges, they have what is called an intranet. In other words, that they can talk to each other on the computers and they have, forums and things that they go into and they have discussions. And sometimes when a judge gets up and leaves the courtroom, that's what he's going to do. He's going to go into his chambers. He's jumping on the intranet and he's saying, hey, look, this guy just brought this into court. He's getting some type of recommendations from other judges of how to handle you in court. Okay, if you present something to him he's never heard before. And just to, just shed light on this, even in my federal case, one of the things that the prosecutor did was they raided my house, and in raiding my house, they found all my paperwork. And they found all the documents I was reading, and they presented it in evidence as exhibits, court exhibits in evidence. And she sent them to me in my cell just to let me know that we know what you've been reading. We know where you're getting your information from. Okay, so be aware of the fact that they know all this stuff that you're doing. Okay, now the reason that you have to study and the reason that I am telling people to do things the way they do is because, first of all, I have experience. The next thing is that I'm telling you to study so you can kind of develop your own presentation so you can come into court with something they haven't ever heard before or present it in a different way that they may not be accustomed to. There is a document on the internet called the Court Survival Guide. You can Google this right now. Just put in the Court Survival Guide.pdf. If you ever want to find a document on the internet, just put the name of the document, then put .pdf after it, and it'll pop up. Okay, a lot of these documents on the internet, you don't have to go to websites or anything like that. You can just just get the document off the internet. But this document, another document called Creditors and Their Bonds, and a lot of people saying right now it's equity. Well, Creditors and Their Bonds been saying it's about trust and equity since 2000. In the back of the damn document, it got a building equity in there for you. So I don't know why these guys are talking about it's all about equity remedies, because we've been knowing that for the last, well, I've been knowing it for the last, it's 2018. I've been knowing about it at least 13 years. Okay, even though I didn't understand equity completely at the onset, I've been told it's an equity remedy from the very beginning, and it's in all the documents that, I'm presenting to you as far as it being a trust too. What's going on in the courtroom is they are doing what is called a constructive trust in equity. Okay, it's called a constructive trust. And a constructive trust is a legal fiction. If you look up the definition of legal fiction in a Black's Law Dictionary, and as a matter of fact, I think I might have it in one of these right here. But I think you get an 8th edition, and you'll see it'll tell you that a constructive trust is a legal fiction, and you are appointed what's called a trustee ex officio, is the name, is a Latin term for it, because the trustee holds all of the liability. There is another document I want you to Google. It's probably not that prominent on the internet, but it's called The Matrix and the U.S. Constitution. Put in The Matrix and the U.S. Constitution.pdf. I got this document probably around in 2008, 2009, something like that. And in this document, this particular person is suspected that the guy named Judge Dale is the one that actually wrote this document, but it doesn't have the author's name on it. And in here, it talks about appointing the judge as the trustee. One of the things in the later editions that they removed that I noticed was that in the earlier edition, it told you that you had to be on the record and you had to be very careful, okay? And this is what I'm talking about with guys that come in and they'll just tell you, well, you just go in court and say this right here. No, you got to be on the record. You don't speak until you're on the record. All right, you don't answer any questions. All right, and your demeanor has to be of a sort that you understand, that you appear that you know what you're talking about. All right, because the judges are trained in psychological pressure. And that's why when you go into court, the judge will be screaming at you or saying different things, you're crazy and things like that. And you don't understand that that's all an act. So you have to put your mind in a place that, why is this judge mad at me? He doesn't know me. And next, he's an administrator. He's not above you. All men are equal under the law. Okay, you're not disrespecting him by asking questions or anything like that. So you got to be prepared for that, the psychological pressure that's going to be placed on you when you go into court. For instance, like what happened to me. I was going through the court system and I got to a district court superior judge. And, as soon as I walked in the courtroom, she started screaming at me. I ain't even said anything yet. This is my courtroom and you're going to speak only when you're spoken to. Do you understand me, sir? Now, some people would not normally get upset about that, but we're a nation of laws, not of men. All right? You have to remember that fact. And these are public servants. They work for you. You got to remember that fact. All right? You're innocent until proven guilty. You got to remember that fact. You got to remember all these things. All right? So you sit here. Now, my simple response was, am I to understand the honorable judge has made a judicial determination that I'm not to be afforded my due process rights of freedom of speech in these proceedings? For the record, that's how you handle that. Another technique that you're going to see that judges like to use a lot is interrupting you. They interrupt you to throw you off, okay? So you might be speaking and then you'll get interrupted on the internet called Moore's in Court. I used to use that video a lot to teach classes with. It's nothing against those brothers. One of the brothers, as a matter of fact, he's on my show, and I mean, they to me demonstrated,
All right, sir, you've had an opportunity to
the
consult.
attitude
Yes,
that you
ma'am.
need to have when you go into court.
Just for the record, I'm a Moorish American Aboriginal Indigenous man.
Hold on, I'm going to write this down.
I'm a Moorish American Aboriginal Indigenous man.
You're talking too fast. Moorish American, Aboriginal,
Indigenous, sovereign man. Okay? And as far as jurisdiction, man, according to case law, federal Supreme Court statutes, there's no discretion to ignore lack of jurisdiction. See,
Sir,
Montana.
I'm going to interrupt you because I'm going to repeat once again. We haven't even gotten to the issue of jurisdiction yet. The issue is whether you are going to appear in this courtroom with an attorney or without an attorney. Simply that small issue.
I understand your
After we
concern,
decide
man.
that issue, we will then move on to the issue of whether this court has jurisdiction over you, whether the charges are against you, all of those things. But for
Understand,
today,
I just must say, man, to add on to what you're saying, jurisdiction, for the record, can be challenged at any time. See Lantana versus Hopper. I'm raising jurisdiction now, man, asserting my constitutional right, and jurisdiction hasn't been proven.
The privilege against self-incrimination is neither accorded to the passive resistant, nor to the person who is ignorant of his rights, nor to one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be claimed by attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. McAllister versus Hinkle, Commonwealth versus Shaw, Orem versus State. The one who is persuaded by honeyed words or moral suasion to testify or produce documents rather than make a last-ditch stand simply loses the protection. He must refuse to answer or produce and test the matter in contempt proceedings or by habeas corpus.
I haven't even had a rebuttal from the prosecutor, man. There hasn't even been a rebuttal. The judge is not supposed to be the arbitrator. I haven't had a rebuttal once from the prosecutor.
I can assure you I am not an arbitrator.
Understand? I've sent plenty of documentation asking for the returning of the documentation that the prosecutor office holds in regards to the fact of my identity and it proving that the state has no jurisdiction. And jurisdiction, again, can be challenged at any time. See Lantana versus Hopper. The burden shifts to the courts to prove jurisdiction. See 100 SCT 2502. There is no discretion to ignore lack of jurisdiction. See Rosemond versus Lambert 46-9 F2D 416. So, with that being said, man, can jurisdiction be proven for the record? I'm here under threat, duress, and coercion. Because I'm here, I'm not here on my own free will, other than threat, duress, and coercion. On the bail recognizance sheets that was signed, Brandon Casimir isn't signed to that. That's who originally was charged. If you amend the court records to say and reflect that Brandon Casimir is also known as Cheyenne Cushmere Ill or Cheyenne Matola Cushmere Ill and any and all derivatives, that would be improper and that would be illegal and unlawful because I'm not also known as Brandon Casimir. The documentation that was given to the officer was given when he asked. I gave him authentic documentation from the state of New Jersey. That was authenticated, authenticated by the state of New Jersey. That officer had no jurisdiction. He asked where I was traveling. I said Timbuktu. This land is indigenously called Timbuktu. I have the right to assert that right according to Article 6 of the treaty.
I'm going to interrupt you. There are some people that believe that this is the state of New Jersey. You may not believe that, but there are people that believe that this is the state of New Jersey.
Belief is not reason and facts, man. So because the state of New Jersey gives out authentication documentation on West State Street in Trenton, New Jersey, that's why I know the state of New Jersey to exist at. The state of New Jersey is not the soil of the land. So if anyone thinks that the state of New Jersey is the soil of the land, they're sadly mistaken.
Well, I think that there are probably some people that believe that you are sadly mistaken, but that is not the issue today. If you wish to address the issues
of
I
jurisdiction.
have brought before no. My issue today is, are you going to appear with a lawyer or are you going to appear without a lawyer? That is the only issue
I
I
can't
am
make
addressing
an
today.
appearance. I
am not addressing the issue of jurisdiction.
Black's Law 8th edition. Appearance. Expert commentary. The English courts did not, until modern times, claim jurisdiction over the person of the defendant merely by service of summons upon him. It was deemed necessary to resort to further process by attachment of his property and arrest of his person to compel appearance, which is not mere presence in court, but some act by which a person who is sued submits himself to the authority and jurisdiction of the court. Any steps in the action, such as giving bail upon arrest, operated as an appearance or submission. Benjamin J. Shipman, Handbook of Common Law Pleading, subsection 5 at 24. Henry Winthrop, Ballantine edition, 3rd edition, 1923.
Excuse me, ma'am. According to the federal case law in the United States Constitution and the United States Supreme Court,
And when
authority
the
delegated to
issue
him,
is raised properly before this court, I will
being
consider.
raised at any time, ma'am.
Excuse me a moment, please. There is a lot of talking going on in the courtroom that I can hear. If I can hear it, it is being recorded on our recording system. Two things. I don't think you want people on the recording system to know what you're saying. The second is you're interfering with me. If it continues, I will have to ask you to leave the courtroom.
Objection, ma'am. According to Canon 3, a judge to the court to every person who is legally interested in a proceeding or that person's lawyer full right to be heard according to law. Asking us to leave the room, man, is
I'm not asking you to leave the room at all. I'm asking people who are speaking so loudly that they are interfering with the proceedings.
You asked me, am I going to proceed with attorneys? This is my society, and my greatest society exists beyond these walls. They have power of attorney, a written agreement, contractually. That's a constitutional right for us to be able
Well,
to enter
what do
into
you
an
want them
agreement.
to do? Who is it actually that holds the power of attorney?
My entire counsel. This is my counsel.
And what do you want them to do? In this
Counsel,
courtroom
according
today.
to constitutional law.
No. Tell me the actions that you want them to take in
Counsel.
this courtroom today.
Counsel, I want my society members,
Sitting next to you?
yes, counseling me.
That is not going to happen, sir.
Well, that is
When you
improper
need
and
to
illegal, ma'am.
It is not.
According
And
to
when you
Canon
need to
3.
consult with them, you simply tell me. You can step outside. We have a private conference room on the left-hand side. You can consult with them there.
According
They
to
are
the
not
Code
going
of
to sit at the
Judicial
council
Conduct.
table with you.
According to the Code of Judicial Conduct, ma'am, that's not stipulated in Article 3.
There are a lot of things that aren't stipulated in Article 3, including the fact that you and I need to consult with one another. We need to be polite to one another.
Absolutely,
That's not
ma'am.
there.
Absolutely.
So there are a lot of things that aren't there.
I'm being polite as possible, ma'am.
I'm not suggesting otherwise, sir.
Okay? And just to add for the record, once more,
Is this all for the
jurisdiction-
record?
Yes, this is all
Okay,
for
then
the
you let
record.
me know when you're finished putting it on the record, and then you and I will continue with our discussion.
Ma'am, jurisdiction can be challenged at any time. See Lantana versus Hopper. I'm raising jurisdictional issues right now, ma'am. You're asking me to assert whether or not I will have an attorney at law be representing me. That is impossible, unlawful, and illegal, and that is against your constitutional oath if you force me to get an attorney at law. I've already asserted the fact that jurisdiction can be challenged at any time. Courts must prove on record all jurisdiction facts related to the jurisdiction asserted. We can't proceed until jurisdiction is proven.
You finished?
Yes, ma'am.
Okay. The issue we are going to discuss today, and I'm going to repeat this for the
I
last
move the
time,
court, ma'am, to dismiss this case for lack of jurisdiction.
denied. If you
Jurisdiction
want the
can't be
court,
challenged at any time, ma'am.
don't repeat yourself 4 times, please. I listen carefully, I write things down. If you wish to file that sort of an application with the court, it can be filed in writing upon
has already been
notice,
filed, ma'am.
upon notice to everyone involved. I am not going to repeat myself again. I cannot conduct this proceeding with noise from the front row. If you lady, ma'am, and you gentlemen want to stay here, be quiet.
I'm not a gentleman, man. I'm a nobleman, just for the record.
If you are a Moorish American, Aboriginal, Indigenous, sovereign man, whatever you are, be quiet in my courtroom. I cannot do this with people talking in the audience.
Can jurisdiction be proved, ma'am?
Sir, we are not dealing with the issue. I've told you before. You want to raise that issue, you file an appropriate motion.
Has been filed, ma'am.
No, I haven't seen it yet. I'll deal with it when I see it. If it's not in the appropriate form, it's not going to get dealt with.
Though they may have been kind of like inexperienced a little bit with things like informing objections, because when you form an objection, the only thing that you're looking to hear from the judge is sustained or overruled. If a judge starts, if you say objection, Your Honor, and the judge starts saying, what are you objecting for? Okay, that's called an equivocation. The judge is not trying not to commit on the record, all right, because the record is going to reflect that the judge didn't rule on your objection. Tricks and traps used by attorneys, judges, and other species of rats concerning evidence by Valiant Liberty. How attorneys' unsworn statements become facts of evidence and how to prevent it. The trial court has the discretion to admit or exclude evidence. The appellate court will reverse only on the abuse of discretion standard. If the trial court sustains the objection, it will not admit the evidence. The party who offered the evidence still has other options that it must exercise, or it weighs the error. If the trial court overrules the objection, it will admit the evidence. The party whose objection was overruled still has other options that it must exercise, or it weighs the error. An attorney's unsworn statements are not evidence. U.S. Gov. versus Marks. However, on appeal, a lawyer's unsworn statement can be considered evidence unless the other side objected at the trial. Normally, an attorney's unsworn statements must be under oath to be considered as evidence. If a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn and subjected to cross-examination. When in doubt, a lawyer should always object to the fact statements of another lawyer.
We thought we'd better ride over ourselves and investigate.
And what did you see when you arrived?
An old woman was out in the yard, dead with blowflies on her face. The old man was inside with his breast blown open by a scatter gun and his feet burned. He was still alive, but just was. Said it was them two Wharton boys done it and rode up drunk.
Objection. Hearsay.
Signed declaration, Your Honor.
Objection's overruled. Proceed, Mr. Coburn.
All them two Wharton boys, that'd be Otis and CC, throwed down on him. Asked him where his money was, and when he wouldn't tell them, they lit pine knots, held him to his feet. They told him the money was in a fruit jar under a gray rock at the corner of a smokehouse.
And then?
Oh, he died on us, passed away in considerable pain.
What'd you do then?
Well, me and Marshal Potter went out to the smokehouse, and that rock had been moved, and the jar with the money in it was gone.
Objection. Speculative.
Sustained.
You found a flat gray rock in the corner of the smokehouse with a hollowed out space beneath it.
If the prosecutor's going to give evidence, I suggest he be sworn.
A lawyer should always object to the fact statements of another lawyer. If the other party is aware that the lawyer is testifying and does not object, the administration of the oath is waived. A party should attempt to secure an explicit ruling admitting or excluding evidence, that is, a ruling on the record, either in open court or in writing, that specifically state the court's ruling. In other words, that the objection is overruled or sustained. If the court does not make an explicit ruling but admits evidence over a specific objection, the court's implicity overruled the objection and the error is preserved. If the court does not rule, or if no ruling appears in the record, the error is waived. To preserve error, an objection must actually be overruled. If the trial court says that it will rule on the objection later, the statement is not a ruling and does not preserve the error. TEIA versus Moore. If the trial court invites the party to re-urge the objection later, that is not a ruling. Bushell versus Dean. If the trial court responds to an objection by saying, okay, that is not a ruling. Walmart versus Gonzalez. Comments. These type of rulings are called equivocal rulings, and any ruling on an objection to evidence that is not overruled or sustained is an equivocal ruling and does not preserve error. So anything that judge says after you form an objection, all right, you just patiently wait for him to get through speaking, and it doesn't matter what he said. I don't care what he said. If he doesn't say sustained, overruled, the next thing should be out of your mouth, if he doesn't say sustained or overruled, is I take exception to the honorable judge refusing to rule on my objection. Would you please enter sustained or overruled into the record so I can preserve the error? All right, it's called a preservation of the error. If he doesn't say sustain overruled, you're not preserving the error. There's no reversible error. So there's nothing for you to take on to appeal. The next thing, if you're like in a foreclosure case, you need to be sworn in. If you're coming to court and you begin talking, you're not sworn in. Everything you say is hearsay. Okay, the only thing admissible is testimony that has been adhered to. Okay, and you do that either through deposition, affidavit, notarized documents, or in-court testimony. You come in and swear and tell the truth, the whole truth, nothing but the truth, so help you God. Okay? But if you come in the court and you just come in there and you just start talking and you haven't been sworn in, the judge is going to take what is called silent judicial notice of that fact. And he has discretion on whether to accept your testimony or not. You're giving him discretion. So these are little tidbits and tricks. You know, you come into court and you say something like, people say, well, they got a thing I'm seeing right now. They talk about subrogation, because you're a third-party intervener. That's under Rule 24 on the Federal Rules of Civil Procedure, because the straw man is not you, okay? It is a fictitious entity, okay? It's too fictitious. That whole Article I court system for commercial-type matters is they're dealing with fictitious entities.
Real talk, real people, real radio. HighFrequencyRadioNetwork.com.